Welcome to the Library Channel. From Arizona State University, I'm Fred McIlvaine. This is a three-part series on FORO 2007, the Transborder Library Forum held at Arizona State University in February of 2007. The theme for this year's conference is Bridging the Digital Divide, Crossing All Borders. Each episode includes one of three keynote speeches which addresses how libraries can facilitate access and exchange of information, resources, and culture through technology. Crossing All Borders. In Part 2, International Copyright in the Digital Age, Dennis Karjala, the Jackie Brown Professor of Law at the Sandra Day O'Connor College of Law here at ASU, considers the basic notion of intellectual property and problems with its legal protection, why too much protection is a bad idea, why enforcement is sometimes difficult, and why the scope and duration of the intellectual property rights are limited in comparison with rights in tangible property.
We're privileged today to welcome Dennis Karjala, who was an engineering physics major at Princeton University and holds a PhD in electrical engineering from the University of Illinois. He received his JD from the University of California, Berkeley in 1972, where he was editor-in-chief of the California Law Review, an order of the Coif. Professor Karjala joined the College of Law at Arizona State University in 1978 as associate professor after 5 years of private practice in San Francisco. He has been a professor of law since the fall of 1981 and currently holds the Jack E. Brown Chair. His teaching and research are primarily in the area of intellectual property law, especially copyright and the application of intellectual property law to digital technologies. Other areas of teaching and earlier writing include corporate and securities law and federal income taxation. Professor Karjala has also done some comparative work on Japanese copyright and corporate law. He was active in trying to stir up opposition to the 1998 Sonny Bono Copyright Term Extension Act and the Eldred case, unsuccessfully challenging the constitutionality of that legislation. Please join me in welcoming him to the podium.
Well, thank you to all the organizers for inviting me to come this morning and talk to you about copyright and international copyright, especially in the digital age. What I'd like to do this morning, or what I plan to do, and I don't know, hope this meets, at least in general, with what the kinds of things that you're interested in. I thought I'd talk a bit about the nature of intellectual property and why we have special rules for it. Then I want to talk a little bit about the distinctions between copyright and patent law, not so much because I think you, as librarians, really run in very directly to patents, but the digital age has really forced us to think much more closely about this difference, and I think it's worth talking about, at least briefly. Then I'll talk a little bit about I'll go on, at least outline some of the international coverage of copyright, the most directly digital oriented aspect of copyright law, which is our Digital Millennium Copyright Act, the DMCA. And then I'll finish with some specific problems concerning that the digital age poses for copyright, especially P2P Networks and the Google Book project. Okay, now what is intellectual property? In thinking about this, we should. It's useful to contrast what we call intellectual property with tangible property. Tangible property is a zero-sum game. If I have a watch to tell the time, Sherry no longer has it. We can't both have it at the same. This happens to be Sherry's watch. I stole it. A piece of tangible property can really only be used or consumed by one person at a given time. And the result of this is that without property rights in tangible property, we can suffer what scholars are now calling the tragedy of the commons. It can get overgrazed. If nobody has property rights, everybody tries to use as much of the resource as they can as soon as they can, for fear that if they don't, everyone else will use it up anyway. So the recognition of property rights and tangible property addresses a number of important problems. It eliminates some externalities and reduces the negotiation costs and transaction costs of eliminating other externalities. Intellectual property is very, very different. Intellectual property is not a zero-sum game. If I write a song, your singing it doesn't take away my ability to sing it. Might not be good to sing it in the same room, but we can all use it together, and it can be infinitely multiplied. Everyone all over the world can sing the same song. I still have the ability to sing it and enjoy it regardless of what they do. And the reason is so additional copies can be made essentially without cost. And creating an artificial scarcity by recognizing property rights is economically inefficient. I won't go into why. If you want, we can talk about that later if you'd like to do so. So one of the problems is this we would prefer not to recognize property rights in intellectual property if we could avoid it, because it's economically inefficient. Now, the other problem, though, is intellectual property is like a public good. That is, once it's in existence, it's difficult, not always impossible, but difficult to exclude other people from using it. Once the secret formula is public, or once copies of a book or a movie or a song are generally available, it's very easy to copy, and it's very difficult to keep people from copying without some legal rules. So intellectual property law is designed to balance this incentive inhibiting public goods problem, because people would be reluctant, we think, to create intellectual property if they can't appropriate to themselves at least enough of its value to cover their costs of production. And many of them, of course, would like more if they can get it. But at least their cost of production. If they can't get that, the people will just drop out of the creativity producing business. So we want to maintain some incentives. On the other hand, we don't want to, we really have to worry, we should worry at least, about the economic inefficiency of giving property rights to something that's really infinitely reproducible without costs. And so this is the balance that we're trying to achieve with statutes like copyright and patent. Now, we've been constantly tweaking these statutes over the years, as you librarians probably know better than anybody. But the digital age has exacerbated the challenge to copyright owners, because copying and worldwide distribution is now easy and cheap, and enforcement is thus much more difficult. This in turn leads to new legislation like the Digital Millennium Copyright Act, supposedly aimed at maintaining the balance. One of the issues we want to talk about is how well it's doing that. And of course, there's also at work a lot of self-interested attempts to maintain a bigger slice of the pie for current copyright owners. The best example of this is the recent copyright term extension and the Sonny Bono Copyright Term Extension Act in the United States. I blame the European Union as much as I blame the United States for this, but nevertheless, the damage was done. It's an unmitigated disaster as far as I'm concerned. Raises costs to the public, transfers wealth to the descendants of owners, to the descendants of creators, people who themselves have contributed nothing to the work in question. Does absolutely zero to increase creation incentives. And it keeps many works out of the public domain where other authors, current authors, can use them to produce new works. And that's a political problem that exists everywhere. It's not peculiar to the digital age, but it's one where its effects we might see now much more strongly, because digital technology, as we all know, is making lots of new possibilities that were not even conceivable in an earlier time. things like, for example, the digital book project. Let me make just one aside also on the basis or the basic concepts of intellectual property before getting into some of the details. And this has to do with so-called natural rights basis for intellectual property. Many people argue that creators ought to be able to control their intellectual property simply because they created it. That is, by creating it, they have a natural right to control the use of it. And so by analogy to tangible property, natural rights advocates argue that, well, I created this, whatever it is, this song or this novel or this movie, or maybe this invention. And like rights in tangible property, the property rights ought to go on forever, be perpetual. That argument is often made, and with a straight face. Now, as a practical matter, this natural rights argument ignores the fact that nearly everything, really nearly everything, builds on something else. So unless we're going to define IP rights really super narrowly, perpetual property rights would end up essentially, everything would be so tied up in getting permissions that pretty soon further production, I think, would be literally impossible. More important, though, when you hear these people talking about natural rights, you should know and understand there's no legal system, certainly none that I'm aware of, that has ever relied solely on natural rights as a basis for intellectual property protection. That includes France, supposedly the great copyright country. Not even France relies on intellectual property rights. Every country has a limit, allows these rights to expire. Now, why do we do that? Just think about it for a minute. Does anybody believe, do you feel guilty when you get out and ride your bicycle that you're not paying royalties to the descendants of whoever invented the wheel? I don't think so, right? Things go on. Maybe a little bit more problematic, but not for me anyway. Does anyone think that Einstein should have any rights, let alone perpetual rights, to his theories of relativity? He doesn't. We don't give him that. Nobody gives him that. No country, not even France, gives him that. Nobody gives it to him, and there's a good reason for it. The reason is we like the theory of relativity. That's very creative. I mean, talk about creativity. It's hard to imagine anything that's more creative than that. This is a supreme effort of the human mind. And yet we don't give them any intellectual property rights. Why not? Well, for one reason, we don't have to. We give it to us anyway. And people and scientists like that do generally work, not with the idea of controlling their knowledge, but with the idea of dispersing it. So we know that we don't have to give intellectual property rights in order to induce this creation. And we know that giving intellectual property rights would inhibit the further growth of our understanding of the natural world. And then if you take a look at patents, patents have a much shorter term of protection than copyrights. Why is that? Well, just think about it. Do you think that a patent on a functional work should go on for 95 years or life plus 70 years? It's crazy when you think about it. If the current copyright period of protection had been a part of patent law a century ago, the initial patents on the automobile would just be expiring about now. That would mean that all of the developments in automobile technology would have been under the control of essentially a single patent owner for this entire time. It's ridiculous. So these examples, I think, show that looking to so-called creativity, as much as we like creativity, I'm all for it, I like creativity as much as anybody, but looking to creativity as a basis for natural intellectual property rights is at best misguided, and at worst, it's a smokescreen for fooling people into supporting longer and stronger rights in the present generation at the expense of future generations of creators. Not all creativity is protected by copyright, and under the idea expression distinction of copyright, often the most creative part of a work is in fact deliberately left unprotected. Not all courts remember this when they make decisions, but that's certainly the basic, that's a basic truth about copyright law and should be universally recognized, and is generally. Furthermore, not all creativity is protected by patent. Even we don't get patents. Even again, just take any scientific theory like the theory of relativity, you can't get a patent in that. You apply it to something practical, you can get a patent in that application, but not in the theory itself. Okay, let's talk now a little bit about the difference between copyright and patent. Copyright has historically been reserved for non-functional works of literature, art, and music. Copyright, as you I think probably all know, arises automatically in the United States with fixation. In most other countries, you don't even have to fix it as long as you have a conception of it. And copyright is also automatically international. As soon as copyright attaches in any country that is a member of the international treaty, which is essentially every country in the world, protection is available in all of those countries under their respective copyright laws. Registration of the copyright is necessary for United States works in the United States if you want to sue somebody on the copyright, but it is not a condition to actual existence of the copyright. Now, the protected works have to be original in the sense that they arise out of the original efforts of the author, and originality requires at least a modicum of creativity. I was looking around yesterday. In giving talks like this, you like to have a few jokes or some humor, and so I went on Google to looked up intellectual property humor, copyright jokes. I really couldn't come up with much, so maybe copyright isn't a very funny subject, but I did see this one little blurb somewhere. Some people, I forgot now if they were where they were. Anyway, what they did was they set up some mechanism for basically writing down all the possible combinations that you could dial on a touch-tone telephone. And then they claim copyright in all the melodies that result from punching in those combinations. And then they say they're entitled then to a royalty from everybody who ever uses a telephone, because you use a telephone, you're playing their song and infringing their copyright. Now, I think this was done, this claim, of course, I'm sure was done tongue-in-cheek, but it's an interesting, as I thought about it, it's actually, I'm going to give it to my copyright class next year because it raises all kinds of interesting copyright issues. First of all, I doubt very much that there would be, even if they had a copyright in the songs that they wrote down, if you just dial a telephone, you are not copying, you at least are not making, maybe the telephone company is making a copy of the number, but you aren't making a copy of the song, it's only being played in your ear, nowhere else, so it's not a public performance. So I don't think there would be an infringement simply from dialing the telephone number. But more importantly, these songs would lack, there certainly is no creativity. They're all just generated by whatever computer program gave them their lists of numbers. And so they would lack certainly the modicum of creativity, and in fact they probably wouldn't even be original because they didn't think up the numbers or the songs themselves. They simply got them out of a mathematical formula. So it's a kind of a clever idea, but it wouldn't have worked. Okay, as you know, copyright protects only the expressive elements of works, not the so-called ideas that express them. An independent creation is a defense to copyright. That's another thing that would limit these telephone songs, because if you dial a number, you're not looking at their song and say, "Oh, that's a nice song. I think I'll play the song. It gives me whoever answers. I'd like to talk to that person." That's not the way you do it. You dial the number because you want to get in contact with somebody else. So again, that would be an independent creation of their song, not a copying of it, and it wouldn't be an infringement anyway. Okay, the copyright is infringed, certainly by verbatim copying, unless it's fair use, or even substantial copying of so-called protected elements, that is, the expressive elements as opposed to the ideas. Now, and that's another thing. I know you all have heard about this idea, expression, distinction. Most people, I think, develop with kind of an intuitive sense of what this means, or at least what they think it ought to mean. All I'll say on the subject is forget it. There is no way, I really mean this, to tell what is idea and what is expression, except by reading a lot of copyright cases and seeing what the courts have told us about it. They are not analytically useful terms. They're conceptual terms. We know that there's some elements of a work that are not protected. We call those the ideas. And we know there's other elements that are protected, and we can call that the expression. But it's only after you've decided whether an element is or isn't protected that we know whether to call it idea or expression. To say, well, that really is an idea, so it isn't protected, doesn't get you anywhere. Patent law is very different from copyright, and this is the point that I really want to try to make. Both copyrights and patents are aimed at the same general goal, that is, protecting and incentivizing the fruits of intellectual creativity. They both try to do that. But they do it in very different ways. For a patent, as I said, copyright, you remember, arises automatically upon fixation in this country and just upon creation anywhere else. To get a patent, and this is true everywhere, you have to file a formal application with a patent office somewhere, and the patent has to be approved and examined by skilled examiners, and they look for the substantive elements of patentability, such as novelty and non-obviousness. Copyright is automatically international, as I mentioned, but patent is not. You actually have to file for patents in all the different countries where you would like to have patent protection. Recent developments are making that international filing procedure easier, and it'll probably get even better or easier and smoother in the future. But still, you actually have to go through some formal procedure. The non-obviousness requirement is supposedly a higher creativity jump than is required by copyright. Copyright only requires a modicum of creativity. Patents are infringed only if you make, use, or sell something that incorporates all of the elements claimed in a valid patent. And whereas copyright has this vague scope of protection if it's substantially similar to protected elements. It's another very difficult judgment as to whether something is or isn't infringing if it's not a verbatim copy. And patents only last for 20 years from filing, as opposed to this nearly infinite period now that we have for copyright. So we have these very, very big differences in the way we treat patent subject matter and copyright subject matter. And it's interesting to ask, why do we have these differences? It may surprise you to know that even though these statutes, even in this country, mutually coexisted for a couple of hundred years before the digital age, almost nobody thought about what the difference was between patent and copyright subject matter. Everyone just sort of took it as obvious. And it was kind of obvious. Copyright protected art, literature, and music, and patent protected functional stuff, useful stuff like machines and things like that. And it was always, there really wasn't much subject matter that really caused overlap problems. So patent for many years was said to exclude things like business methods and mental steps, operations that you could just carry out in your mind. Those doctrines have been thrown by the boards, and now a patent is said to give protection to anything, anything under the sun made by man, except with the exception possibly of abstract ideas and laws of nature. Really, it's very surprising. You can go read decisions of our patent appellate court, the federal circuit. This is the kind of thing they'll say. Patent protects everything under the sun made by man except laws of nature and abstract ideas. They don't even bother to mention that it doesn't protect traditional copyright subject matter, art, literature, and music. Nobody thinks that you can go write a novel and go get a patent on it, or paint a picture and get a patent on it. It's a huge amount of subject matter, and they don't even bother to mention it as one of the exceptions from patent subject matter, again, because I think they're just treating it as obvious. Computer programs, though, have thrown a monkey wrench into this operation, because suddenly with computer programs we had something that looked a lot like copyright subject matter. You could write out the program in human intelligible symbols, but also just as obviously, once you got that source code converted into machine signals, it operates a machine like gears and pulleys and things like that, except just much faster and smaller. But it's physically, it's all physical operation. And so the question, really the question should have been asked, it wasn't early enough, but it should have been asked then, okay, now what then is the difference between these two types of subject matter? And I've been now preaching for, I don't know, 15 or 20 years that the difference is in a particular notion of functionality. That is, something is functional if it has an intrinsic utilitarian function other than to portray its own appearance or to convey information. So information, just the conveyance of information as such, no more, that's sort of traditional, that falls within the traditional realm of copyright. Portraying an appearance falls within the traditional range of copyright. So if it's not a question of usefulness. This is the important thing. It's not just the merely useful that excludes something from copyright. Almost everything is useful. The picture you put on your wall is useful for decorating your home. That toy you give to your child is useful for keeping him occupied, maybe even giving him some educational dexterity benefit, who knows what. There are lots of useful things to which those objects can be put. But their use inheres in their appearance. The reason the picture decorates your home is because it portrays the appearance that it gives. You like it. Maybe someone else doesn't. It doesn't make any difference. That its use inheres in the fact that it portrays its own appearance. Maps, dictionaries, rule books, recipe books, things like this, often said to be functional works that are copyright protected, really aren't functional, at least in this definition, because all they do is convey information. So that keeps all that stuff in the traditional realm of copyright and leaves for patent those items that have an intrinsic utilitarian function beyond simply conveying information or portraying an appearance. Now, I won't elaborate further on this. I've written a lot about it. It's an interesting and complex subject and raises a number of problems for lots of items that come up in copyright cases. Not so many of them, though, I suspect directly related to librarian functions. But I'd be happy to talk about it if you want to. As I say, computer programs have thrown a monkey wrench into all this because they have a bit of both. They look a lot like literary works, and they act a lot like patent subject matter. And without really realizing it and without carefully looking at the distinctions between traditional patent and copyright subject matter, we in the United States, and through the United States efforts, essentially now the whole world, have decided to put computer programs under copyright. You can still get patents in computer programs or aspects of them as well, but the most important and I think most perhaps deleterious protection is from the results from the blind application of copyright law to computer programs. Now, so I think it was a mistake to do what we did, to put them directly under copyright. Still, I think we have to concede that with respect to computer programs, and especially if you look at things from the 1980s, things have changed a lot since then, but if you look at what was knowable about computer programs back then, they looked like things that were quite expensive, time-consuming, and difficult to create, and really super easy to copy. All you had to do was take the disk that you bought the program on, stick it into a slot, put a blank disk in another slot, and in seconds you've got copies. You can make hundreds of copies in an hour and sell them in competition with the producer of the program. Exact copies. They're every bit as good as the one that comes from the original creator. So it certainly appeared that we needed some sort of protection for computer programs. We should have adopted a sui generis statute aimed specifically at computer programs. We could have had a much shorter term, which would have been valuable. And we could have perhaps distinguished application programs from operating systems and thereby avoided the Microsoft problem, where we now find ourselves where one company basically controls the gateway to personal computing. Still, as I said, we probably need something like copyright. Even if we had adopted a special sui generis statute, we would have ended up with something like copyright, hopefully for a shorter term, for computer programs. And today, I think, notwithstanding the bad fit of copyright to computer programs, courts have limited protection pretty much to the verbatim code. And most of the other functional aspects of computer programs are not covered by the copyright. They're relegated to where they should be, to patent law. And although, as I say, the field is still messy, it's one that I think has not worked out as badly as it could have. Okay, now internationally, let me see here. We know we have three major treaties. Going back over 100 years, we have the Paris and Berne conventions for so-called industrial property and for copyright. Paris covering patent to some extent, and patent, trademark, and various areas like that, related areas. The Berne Convention on Copyright giving some fairly detailed minimum standards that each member country had to adopt in their domestic copyright laws in order to be in compliance. The problem with both the Paris and the Berne Conventions was that there was no enforcement mechanism in them. So a country that was not in compliance really suffered no ill effects. And in order to repair that, TRIPS came along in the 90s, and that was the trade-related aspects of intellectual property rights or something like that. I can't remember exactly what that stands for. Makes intellectual property a matter of international trade law. Member nations now of the WTO, the World Trade Organization, must adopt substantive copyright and patent laws incorporating the minimum standards of Paris and Berne, and going further in some specific areas that are unique to TRIPS, such as express provision for computer programs. Under TRIPS, that each country has to protect them under copyright as literary works. TRIPS prohibits making exceptions to the kinds of copyright rights that countries adopt, and it limits the exceptions to certain special cases which do not conflict with the normal exploitation of the work and do not unreasonably prejudice the legitimate interests of the right holder. I won't go into it now, but if you think about that language, it could easily be that the United States version of fair use puts us out of compliance with TRIPS. It could be a major shock, a major disaster. On the other hand, if we had to get rid of fair use, it might become unconstitutional. So then that might be the way we would get out of it. Anyway, no one's challenged our fair use provisions yet, and so that still remains an open question. The most important thing is that TRIPS now supplies the enforcement mechanism that was missing in Paris and Berne. It's only done at the national level, but if a country does not have on their books the substantive copyright and patent laws meeting the requirements of TRIPS, or if they're not enforcing the laws properly, then panels can be convened under the WTO to sanction the countries that are in violation. Okay. One more international treaty that's probably worth mentioning is the World Intellectual Property Organization Copyright Treaty from the mid-90s again. I can't remember exactly when, 96 or so, requiring member countries to give adequate legal protection and effective legal remedies against circumvention of technological measures that are used by authors to protect their works. Now, I think we could have argued that our law was already in compliance with this requirement, that we had enough in the way of just our copyright law was sufficiently strong, given our views of what constitutes copies and so forth, that we were already in compliance with this provision, but we responded nevertheless with the DMCA in 1998. And this statute, again, has been much criticized, certainly by the academics, including myself. I'll just try to summarize a little bit about what it does and talk about some of the exceptions and just kind of give you an update on where we are. The DMCA there's sort of three substantive provisions. It prevents circumventing technological measures that effectively control access to works. Access. So, again, think you go to a website and you need a password to get in to read, say, the newspaper articles or whatever are at that site. Okay? If you circumvent that technological measure to get into that site without the password, arguably you are then circumventing an access control. You're probably also making a copy in RAM of your computer when you make access, but it's just the circumvention of the access control itself that is a violation of the DMCA. And then the DMCA prohibits trafficking in devices that help other people circumvent either access controls or copy controls. You may remember, again, from the 80s, programs for a while were distributed in a form that prevented them from being copied, or tried to. Some software was on the disk that would prevent you from making copies. And DVD technology today has similar kinds of controls. Those controls prevent you from copying, prevent you from taking a disk, sticking it in your slide, and making another copy. So that's a copy control. That's not so much access control, because you can play that, you can run that program on your computer, you just can't make a copy of it. So access control and copy control, two different things. The DMCA does have some limitations. It supposedly doesn't affect any rights and remedies under copyright law, including fair use, but there is no express fair use anti-circumvention exception. You can't say, well, I circumvented, sure, I admit, I circumvented this technological measure to get access to this work, but I only made a fair use of the work. So that ought to be a fair use to do the circumvention. If I can make a fair use of the work, why can't I do the circumvention? Well, the courts have pretty uniformly held that there is no fair use defense to the circumvention, even though it would be a fair use, that whatever use you were going to make of the work if you got to it. Nonprofit libraries have an exception. I don't know. Maybe it's more important than it sounds to me, not being a librarian. But you can circumvent a protected work to gain access to a copy only for the sole purpose of making a good faith determination of whether you want to acquire it for a use that's not otherwise illegal. And then you have to get rid of your copy as soon as you've made the determination. And you can't even do that circumvention if an identical copy is reasonably available to you somewhere else. So it seems to be quite a limited exception. I don't know if Be interested to know if anyone ever makes use of that. And incidentally, you're authorized as librarians to do the circumvention. But if you don't know how to do it, you won't be able to find an anti-circumvention device that you can buy because there is no exception to the anti-trafficking rules. So you have to be a pretty good programmer if you want to take advantage of some of these exemptions. Another exemption, again, solely from the anti-circumvention claims and not from the anti-trafficking rules. Library of Congress every 3 years determines certain classes of works that deserve exemptions because they wouldn't adversely affect copyright owners, and there are some particular needs for the users of works of this class. And they have hearings, and people submit proposals and things like this. This goes on every 3 years, and we just did one. Jenny asked me to mention some of them that are relevant to librarians. Now there is audiovisual works that are included in the educational libraries of college media studies department, where the circumvention is done to make compilations of portions of the works for educational use in the classroom. So again, if you've got movies, whatever, that are in your media studies department, in your film department, and for some reason you can't access them because of an access control, if you can figure out how to circumvent them, then you can make excerpts, which would presumably be a fair use if you just took excerpts from different movies and put them together. Anyway, that's now allowed. Computer programs and video games distributed in formats that have become obsolete. When circumvention is accomplished for the purpose of preservation or archival reproduction of published digital works by a library or archive. So that's another one that you can circumvent if you can't otherwise get to it, if it's for archival purposes. And then a few others. Literary, this isn't really directly for librarians, I guess. Literary works distributed in ebook format. When all existing ebook editions of the work contain access controls that prevent enabling the read aloud function. So this is one that was in favor of the Association for the Blind argued for this one, that if you can't get the read aloud function, if that's turned off and there's no other way to get there, you can circumvent for that purpose. The register rejected a number of proposals, including proposals to allow so-called space shifting, that is, taking a work that you legally own, putting it on a different medium for more convenience in listening to it. So if you have a CD of music, now copying music is probably not a good example because there's exemptions. But let's suppose it's a movie. You got it on a DVD, and you'd rather put it on your iPod. I don't know. Can you do that? Can you do that? You can put, anyway, you will be able to do. I don't have an iPod. I don't know how this. So if you can put a movie in a form that would fit in your iPod and take it with you, that would be an example of space shifting. You own the actual movie. You bought the DVD. You're free to watch it as much as you want. It's just that you like to have it in a different format so you can play it on a different machine. And they argued that you ought to be able to access or circumvent access controls in order to do this, and the register rejected that. On the ground that there are other ways to accomplish these results, and you don't need an exemption from the DMCA for that purpose. Regional codes, country codes, are another example of this. That if you buy a DVD in Europe and bring it back here, you find that you can't play it on your own machine. So you own a copy, and you can't play it. And so people argue, well, you ought to have an exemption for that, so we could circumvent these regional controls and play it. I mean, after all, we've paid for the movie; we have a right to see it. And the register rejected that. On the ground that, it's not that hard. You can get it converted. There's a conversion shop here in town. They'll convert these at least for videotapes. I know I did that from a European format to a U.S. format. One little tape cost me $15 to get it converted, so it's not cheap. But anyway, they say because you can do these things, or you can go buy a European. You can go next time you're in Europe, buy a DVD player over there and bring it back, and then you can play the European ones here. So there's things that you can do. Okay. Let me then try to get into some of the current problem areas in digital copyright. As I mentioned, the DMCA does not recognize an anti-circumvention fair use, so that even if the access controlled work doesn't infringe, because the use is fair, circumventing access controls will violate the DMCA. Or in the worst case, you can think of, take a public domain work, put it on in a digital format, add a little bit of an introduction on your own, that's copyright protected, the introduction is, and then enclose it all in one of these digital fortresses. Then to circumvent, to get at the public domain work would be an anti-circumvention violation, notwithstanding that you're perfectly authorized and you could make all the copies you want of the public domain work if you could get access to it. One can imagine a future world in which so much material will be available only in DMCA-protected controls that the DMCA will allow distributors to charge for access, even to legitimately acquired copies. As I mentioned, this already happens today with DVDs, and it may well happen more in the future. Still, I have to say the DMCA has, at least insofar, perhaps it hasn't been as disastrous for consumers as we feared it might be back in 1998 when it was adopted. A number of cases have denied DMCA liability where the circumvention was for the purpose of compatibility of physical devices like ink cartridges for your printer or in garage door openers, and of course have recognized the importance of allowing competition in the markets for these non-copyright aspects of these technologies. Digital technologies and computer programs, computer software is now in everything. And if we can't get some accommodation so that you can make copies and make adjustments to these computer programs, every piece of your car is going to have a computer in it pretty soon. And your mechanic won't be able to work on it without calling up and getting permission to copy the program. And it's an illustration, I think, of how far out of sync copyright has become in the digital age. The most visible example of a copyright problem in the digital technology is, of course, P2P networks. Now, nearly all the commercial operations, as you know, Napster, Aimster, Grokster, have all been shut down for copyright infringement. But the Supreme Court, perhaps luckily, ducked the most important issue in the Grokster case a year or so ago, when it adopted a new theory of liability called inducement. If your business plan is one that really depends on getting other people to infringe copyrights, which is what Groksters did, then you're going to be liable as a contributory infringer for distributing this device, even though the device has substantial non-infringing uses. These P2P networks have potential for being extremely valuable. They're used by a lot of people for lots of legitimate uses. But because Grokster was really relying heavily on infringement in its business plan through advertising, it was an infringer. The basic rule of Sony, though, still remains intact, and let's hope it stays, which is that the distributor of a device that can be used for infringement, and indeed will be used for infringement, but also has substantial non-infringing uses, that distributor is not liable as a secondary infringer of copyright. It's only the primary infringers, difficult as they may be, to find and sanction. Well, this is an open issue. The Supreme Court ducked it in Grokster. They may come back to it. The software, in any event, P2P software, if those who are not offering it for commercial purposes, I understand. People tell me, again, I don't have any of it myself. It's not because I'm such a good citizen. I just hate loading new software into my computer and taking the time to try to make it work. I almost joined Napster when it was still in existence. I thought sort of a due diligence. I had to see how this worked, and then I went to the Napster site and it said you download this program, you install it, and you do this, and I could see a couple of hours of playing around with the computer in front of me, and I just didn't do it. But anyway, I'm told that this Morpheus and similar software is out there. People are still exchanging music files, and pretty soon we can be sure that as bandwidth increases, we're going to see a lot of DVD movies being exchanged as well. So it really seems to be a problem. I'm close to being sympathetic with the content producers on some of their complaints here. But I think one way to address the problem, or one way to think about it, is to go back to the purpose of copyright. Is the purpose of copyright to maximize revenues to the copyright owners, or is it to promote the creation of works that are available or desired by the public? I think it's the latter. And the only problem, I think from a public policy point of view, is if the piracy gets so rampant that people just stop making music and movies or significantly reduce the production, that we should be concerned. I think, as far as I can tell, there's still money to be made in these industries, and it may be that if incentives have not been significantly reduced as a result of this piracy, maybe we should at least move slowly in creating new forms of liability. Let me conclude with, I think, one of the most important current issues, which is the Google Book project. It's a good example, I think, of how traditional copyright really no longer matches to the digital age. Now, Professor Jessica Littman, who's at the University of Michigan Law School, has been arguing for some time that in the digital age, the notion of copying as a proxy for the interests we're trying to protect in copyright is increasingly off base. As you know, with digital networks, copies are just made all the time. They're made in your own computer and RAM, they're made in your router, and probably in your modem, and the intermediate computers. It's just all kinds of copies are being made of these things as they go from one place to another. It's important, I think, to remember, even though our copyright law, it is true, gives the author of the work or the copyright owner the exclusive right to reproduce the work in copies. That's what our law says. But we have to remember that a copyright owner really isn't harmed at all if copies are made that nobody reads. I could sit there with a photocopy machine and photocopy John Grisham's latest novel over and over and over again, and then throw it in the bonfire. Now, just because, you know what, I hate John Grisham, I just like burning his books, and so this is why I'm doing it. Well, he's not harmed, certainly not harmed economically. And so why should he care if I do that? I submit if he thought about it, he wouldn't care. He might object to my reasons for doing it, if that was my reason, but that's not something that copyright protects against. And so copyright owners are harmed only when copying and distribution results in reduced sales of authorized copies. All right, so the Google Book project, as I understand it, proposes to make all the copies of all the books in the libraries of a number of institutions, like Princeton has just joined, the University of Michigan, I forget, there's a number of major libraries, and they're making copies, just verbatim copies of all these books. Many of them, of course, in the public domain, about which there can be no objection, but many of them, of course, still under copyright. Now, here's what Google is going to do, as I understand it. It will allow copyright owners to opt out. So if you are an author and your book is in the library at the University of Michigan, so it would otherwise be copied, you can contact Google and say, don't copy my book, I don't want to be a part of your system. And my understanding is that they will respect that. Furthermore, if the book is copied and is in their database, Google is only going to allow the reading of little snippets around the search terms that you look for. You're not going to get access to the whole work. And in fact, it will tell the searcher where and how an authorized version of the entire work, if it's copyright protected, can be found. Now, several commentators have already argued in print that these actions by Google should be a fair use. They go through the traditional fair use doctrinal analysis, and I agree with them that it should be held to be a fair use. But I think it doesn't, for our purposes, I think we should go beyond this and look at the underlying interests involved. as I said, making the copy by Google really can't harm the copyright owners because nobody reads it. It's a copy that just sits there in electronic form. Nobody will ever read that copy. Maybe little snippets from it, but that's the most. Google really cannot affirmatively contact everybody, every copyright owner of all these works. It's a huge, huge task, especially for older works, to try to find out who the copyright owner is, and it would make, even for Google, I think that the job would simply be financially impossible if they had to actually initiate the negotiation, and that would and that's really the only deviation that we have to make from traditional copyright to let them go forward. As I say, it's not a great burden for the individual content owners to contact Google. It's pretty easy. The Google Book Project's got a lot of publicity, and it's pretty easy to contact Google. Now, the reason offered by representatives of authors who are opposing Google in a lawsuit on over this project is that Google plans to make money from this project. Well, Google is a profit-making organization. Of course it's trying to make money. And they say, well, okay, you're making money partly off of our works, therefore we ought to have a cut. That, I think, is the best argument that they've got. And let me tell you why I think it doesn't work, or certainly shouldn't work. I don't believe copyright law exists in order to give to copyright owners every last nickel of economic value that can be extracted from their works. Paul Goldstein of Stanford does, I think. But I disagree with Paul severely on this point. That isn't the point. We shouldn't be recognizing copyright rights at all, except that we want to give an incentive for the production of works. Once the works are produced, we want to minimize these rights in the interest of economic efficiency and the broader dissemination of information. If Google, for example, simply thought it could make money by listing the titles and authors of all the books in the libraries, they probably couldn't make money. Let's suppose they thought they could. If they were making money through their advertising or whatever, they would be relying on the existence of these works in order to make money. But neither the title nor the author's name is copyright protected. There would be no objection whatsoever to this plan. When the New York Review of Books writes a book review of a copyright protected book, in fact, the whole magazine basically depends on the existence of copyright-protected books in order for it to exist. I presume it's a money-making operation. They don't have to pay the authors of the books that they review, because each of those reviews is a fair use. So we never have given copyright owners the right to extract every last nickel of economic value that can be taken out of their works. So most important with the Google Book Project, having the ability to do a truly universal search through all the world's literature offers enormous advantages to users of libraries and books. And it's this minimal, it's a technical invasion of a copyright right. It's not even a real invasion of any meaningful right that they have. And if Google or somebody like Google can't do this, it ain't going to happen. This is really almost our one chance, so we really can't blow this one. I think the courts will get it right. If the courts don't get it right, I think the legislature probably will eventually. But I think it should be an easy problem. Unfortunately, the mismatch of copyright with the digital age makes it seem like a hard problem. Okay, thank you. I'll take some questions, I guess.
Thank you for joining us. Please return for part 3, where Alberto Rios, Regents Professor of English at Arizona State University, will recount his personal experiences with books and libraries, and how they can move forward into a global 21st century.